Hi everyone, good morning. Let me just see. Oh, one person is already there. Right. Great. Good to have you here. Very warm good morning on behalf of whole Adroit India team. My name is Ria Chabra and very welcome on today's session on alternative dispute resolution. Can I have your thumbs up so that I know that I'm audible to you clearly before I proceed ahead? Can I just know that? Any reaction so that I know that I'm audible to you? Okay, great. Let me just try one more time. All right, then let's get started with today's session on alternative dispute resolution and how to create your career in ADR. So, do let me know from where you are joining, what you're doing currently. Okay, in the chat box, you can let me know whatever queries you have. Drop your queries in the chat box, and I'll make sure that whatever doubts you have, I'm helping you resolve it. Okay. So the major purpose of today's session is that how many law students are confused about what is ADR, how to create your career in ADR, what are the different career aspects. Like we have heard about ADR and we even have subject of ADR, but no one actually guides us properly. Like if I want to create my career in ADR, how I'm supposed to do so. And this session is definitely going to help you in that manner. So let's understand with a proper understanding of what is ADR. And before that, in today's session, we are going to understand ADR as well as ODR, then different types of ADR mechanisms, how to become an arbitrator and mediator in India, career opportunities for law students and legal professionals, important skills that you need, and how you can develop your CV in order to create your career in ADR, global scope and future trends in ADR and ODR. Okay, so let's get started. All right. So what? Let's understand this from very simple thing. What is ADR? The full form of ADR is Alternative Dispute Resolution. Now, what it is? We'll understand this in a form of like when you have a fight with your sibling, you don't take that fight to the court. Who resolves that fight with you? Your parents resolve that fight, right? Your mother gets in between and tells you, both of you, like manja samajha and all, and then you resolve that dispute. Automatically you both settle it. Now that is what ADR is. In your practical world, in the big world, that is what ADR is, where the parties are not taking up the matter to the court, but they're taking up the matter to a third party who is going to suggest them certain suggestions through which they can come to a settlement, and they're listening to it. So when you have a fight with your sibling, you listen to your mom or dad, right? When they suggest you something like, okay, let it be, let things be, give it some time and all, you come to a settlement. That's what ADR is, where a third neutral party is brought into the dispute and he resolves the matter. So let's say that there's a dispute between the companies. In that scenario, company is going to select one third party who is neutral, and that party is going to come up and give suggestions to them on how they can resolve this matter amicably without going to the court. Okay, so that is the basic meaning of ADR. Now let's understand what is ODR. um do let me know if you're not understanding anything, okay, if it's getting hard for you. Now let's understand what is ODR. ODR is your online dispute resolution. Now ODR is your combination of ADR, that is alternative dispute resolution, plus technology. So the methods what we have been doing in your ADR, when they're combined with technology, becomes your ODR. In let's understand, coming back to our old example only, when you are having a fight with your sibling, in this situation, you and your sibling both are living in two different states, right? Now when you are studying outside, you are away from your family, and in that scenario, if any dispute arises between you and your sibling, your mom is going to call you both and settle that matter, right? So that is, your mom is suggesting you by way of your phone, mobile, or anything. That is your ODR only, where the third party is getting involved online technologically. So that is your online dispute resolution. all the methods that we have been practicing on ADR, when they're combined with technology, they become online dispute resolution. The major difference between your ADR and ODR is that the parties don't have to travel. In ADR, both the parties are at one place. All the three parties, they are at one place who are resolving the matter, who are discussing about the topic. But in ODR, the parties are not at the same place. They are presenting virtually. That means there can be scenario one party is in US, other party is in India, and the middleman, the third party, he's sitting in Europe. And from there, they are discussing and resolving the matter. That is what ODR is. Do give me reaction so I know that you are understanding, okay? Now, let's see what next is there. How ADR is the future. ADR nowadays is the future. We all are aware that courts, Indian courts are filled with plethora of cases. They have got a lot of cases with them, and it takes years for the cases to get resolved. It's not possible for the parties to have justice on time. That is a sad fact. But what companies are doing now, in order to, instead of waiting for the court proceedings and dates, they prefer ADR mechanisms, like a third way through which they can resolve the matter outside court. Now there are huge benefits of resolving this matter outside court. First is that court proceedings take a lot of time, but in ADR the parties have the choice to select the timing, the venue, and how long the overall proceeding will take place. ADR is comparatively a very shorter process. So where the court proceedings are taking 10 years, 20 years to resolve a matter, ADR matters can be resolved within a span of 6 months to 2 years max, considering the case scenario. So if it's a very high value case, it might take a lot of time, but still it will be resolved within a period of 6 months to 2 years max. Now the parties are also getting a chance to select the judge, like select the person who is going to resolve the matter. But in court you don't have that you know that much rights to select the judge. Ultimately, wherever the case is filed, automatically the judge will be assigned. But over here in ADR, you are having the ability to select who is having the correct capability to deal with the matter. So let's take an example that are working in an oil factory. Okay. Now, disputes with regard to the oil factory and oil industry will be different compared to disputes of an IT industry, right? It will be very different. So, you cannot expect a person having a specialty in resolving IT matters to resolve a matter related to your oil industry, because both the industries are different. So you need different people having knowledge about it. So when I know that my industry specializes in oil industry, I'll be picking up the person who has knowledge of oil industry, how things work in oil industry. So in ADR, people having special knowledge about the topic can also become arbitrator. We'll be understanding there are different mechanisms under ADR. Okay, for now I'm just using the common word, that is ADR, covering all types of dispute resolution mechanisms. Now it is also cost effective. If it's taking a lot of time to get resolved, ultimately you are losing out of the money. The value of rupees 100 will not be the same after 20 years. It will not be the same. So what's the use of getting justice at that time when the value is no longer same? Even if I filed a case against you for the dispute of rupees 100, and I'm not receiving that 100 rupees today, I'm getting that 100 rupees after 20 years. The value is not the same, right? It is not cost effective. Secondly, the court proceedings are very much time taking, very much expensive. You have to hire lawyers, you have to manage the case, you have to continuously pay for the fees and so. Secondly, there's also a bad reputation, right? So the name of the companies get publicized, everyone get to know about the company, that a case has been filed against this company, it is the dispute is going on. So it is impacting the goodwill of the company as well. But in ADR, companies can resolve the matter without even letting know the other party. So the general public will not be able to know at all that there was a dispute between the companies, because ADR is very much secretive. Other parties, the general public, will not even get to know that there's a dispute at all going on between the companies and what was the resolution and everything. Automatically this dispute will be resolved between the parties with all confidentiality. Next is flexible procedures and party autonomy. As I already said, that the parties are getting flexible chances on when to, appear for the ADR setting. So for court setups, you get the date from the court, but in ADR, the parties can give their mutual date, and together they can decide on which date and which place they want to come and resolve the matter. Okay, all right. So now let's get started with different types of ADR. There is arbitration, mediation, conciliation, and negotiation. These are the most famous, ADR mechanisms. Now, what is arbitration? Arbitration is a neutral way where we are involving a third party to resolve a matter. Let's start understanding from negotiation. That will be much better. So let's say there's a dispute between parties. Okay, now, in order to resolve this dispute, first way how you can resolve this dispute will be, you'll be communicating with the other party, right? Like, I'm not liking this thing. Kindly do something about it. So let's say that your party has failed to make payment to you. In that scenario, the first step you'll be taking is you'll be reaching out to the party. You'll be asking them, like, kindly make the payments on time. Since you have made this payment late, I'll be charging you interest on this. If both the parties agree to this thing, like other party says, okay, I'll pay you the interest, and going forward I'm going to make the payment on time, the matter gets resolved. This was your negotiation, where I approached you, you listened to me, I listened to you, and together we resolved the matter. This was direct communication between the parties through which they resolved the matter by negotiating on certain points. That is your negotiation. Next is your conciliation. Now, what is conciliation? Same thing, where there's a dispute between us, but in this scenario, we are involving a third party. So, let's say that I approached you saying that please make the payment on time, otherwise, I'm going to take an action against you. And you, on the other hand, said, like, how you can take an action against me? I have been making payment on time and all. You started taking your own defense. So what we are, and the third person observed us and he intervened in between and saying that, okay, I noticed that you're not making the payment on time, and you should be making the payment on time. Let's do one thing. If the payment is failed, you can notify him or call him, or if you are about to delay the payment, kindly notify the other party. So this third person gave his suggestion. He was, he came as the conciliator, he resolved the matter, he gave his suggestion. But in conciliation, his decision is not final. He came between the dispute, he gave his suggestion. Now it depends on us whether we want to listen to him or not. There's no boundage on us that we have to listen to him. So in conciliation, a third party proposes solution. He is going to offer you several solutions that you can take. There's no boundage on you that you have to listen to this solution. Whichever solution fits in your situation, you can pick up that. If it's not fitting in your solution, in that scenario, you can leave it. But in conciliation, there will be involvement of third party whose solution is not binding on the parties till the time parties make it binding. So if both the parties together they decide, like, okay, what this person is saying, I'll agree to it, going forward I'll make the payment on time. In this scenario, the conciliation becomes binding on the parties. Okay, next is your mediation. In mediation, again third party involvement is there. Again third party is coming, same scenario, he's coming and resolving the matter, giving you suggestion, like, you can resolve the matter by doing this thing. Now in mediation, the decision of the mediator, there's a mediator, the person getting in the dispute is known as your mediator, and the person getting into the dispute during your conciliation process is the conciliator. Okay, Now, in mediation, the third person who is coming to resolve the matter is going, his decision can be or cannot be binding between the parties. Now, mediation can be a binding process provided that the parties have agreed to resolve the matter by way of mediator. So, during the contract, during the agreement between the parties, if they had included the clause that the decision taken by the mediator will be final, in that scenario the decision given taken by the mediator will be the final one. In India, mediation is governed by Mediation Act. Okay. Now, the decision of the mediator can be and cannot be binding. There's no compulsion on the parties. It totally depends on if the parties want the decision of the mediator to be binding. In that scenario, it will be binding. Otherwise, it cannot be binding. We are going to also understand the scenario where we are combining arbitration and mediation. Okay. So let's understand arbitration first. Now, in arbitration, the person getting involved is known as your arbitrator. This third party gives his suggestion, and his suggestion is binding on the parties. So in case there's a dispute between two parties and the third party meddling in to resolve that dispute, who is known as the arbitrator. Now, this arbitrator listens to both the sides, then he gives his judgment, and his judgment is considered as binding. In India, arbitration is governed by Arbitration and Conciliation Act 1996. So, the weight of arbitration is equivalent to the judgment given by a judge in a court. Okay, but again, there's a comparison between your arbitration and court proceeding. So that let's understand your combination of these scenarios. First, let's understand combination of court and arbitration. What companies do usually, they can either select one process. Like in case there's a dispute between us, we'll like resolve the matter by way of arbitrational setting. Okay. Now, in this scenario, what they are doing, they are giving right to arbitrational tribunal to resolve their matter. And whatever decision is taken by the arbitrational tribunal, that is going to be the full and final, and that is going to be binding on the parties. It will be given equal weightage to that of the court, like the equal weightage that the judge has given the judgment. Okay, that is your arbitration. This was one scenario. Second scenario can be a combination of both, where the companies can say that okay, in case of dispute, first thing we'll try to do is we'll try to resolve this matter by way of arbitrational setting. Okay, in case we don't like the decision of the arbitration, in that scenario parties reserve the right to challenge the decision taken by the arbitrator in the court. So they have the right to kind of appeal. I'm not satisfied with the judgment given by the arbitrator. I want to, I want to challenge this. I want a different opinion. So I have the right to file a case in the court as well now. So this can be done. It totally depends on how parties are deciding. So this is one way. Next is combination of your arbitration and mediation. Now, in this scenario, what companies can say is the first approach of resolving the dispute will be by way of your mediation. Means we are going to involve a third party who is going to give his suggestions. His suggestions is not going to be binding on us. If both the parties are like not satisfied with the solutions provided by the mediator, then we have the right to take this particular dispute to the arbitrational tribunal, provided that the decision taken by the arbitrator tribunal will be full and final, binding on the parties. So we are giving a two-way approach. One, I'll try to resolve the matter amicably by involving a mediator. The decision taken by the mediator is not final. It totally depends on me if I want to listen to his suggestions or not. If he fails to resolve the matter between us, then we are going to take up this matter to the arbitrator, whose decision will be final. So same happens in marriages as well. When there's a dispute going on between the couples, their family intervenes and they try to, resolve the matter. They try to suggest like, let it go, stay together, don't do this and that. But if the matter gets out of hand, they ultimately file for divorce. They take it to the court, and then things proceed ahead, right? So same is in your corporate setup also, arbitration and mediation, where the mediation is your first way where you're involving a third party to resolve the matter. If the matter is not resolved, then it is taken up to the arbitrator and his decision is going to be the final one. Okay. Now let's understand about your how to become an arbitrator in India. So it is very simple. Every experienced lawyer or a person can become an arbitrator, provided that you have the capability to resolve the matter, you have the ability and knowledge about the topic. So a person, engineer, as well as any other practitioner who have the knowledge in the field, if he adds on a certification or a skill of resolving the matter, can become an arbitrator in that field. And if as a lawyer you want to become an arbitrator, mainly retired judges are hired as an arbitrator, practicing lawyer with years of experience are hired as arbitrator, engineers, academicians, everyone can become an arbitrator. So there's no fixed rule like who can become an arbitrator, provided that you have the knowledge and ability to resolve a dispute. So in India, there are different empanelment of arbitration, like your Indian Council of Arbitration, ICA, Delhi International Arbitration Center, Mumbai Center for International Arbitration. These are the several you know centers in India for arbitration. Students who are planning to create their career in arbitration or mediation, you can try doing it from your law college itself. If you can try adding 1 or 2 years of experience in litigation, that would be good. Other way you can do it is, of course, add a certification, add several certifications about your arbitration in your particular CV. So even Ledroit have got a course on ADR. You can check out our website www.ledroitindia.in, where you are going to learn about how the dispute gets resolved, what are the negotiation tactics, and everything you're going to learn. Ultimately, in order to become an arbitrator, you can, once you have graduated in that scenario, you can find a job under, there are like many arbitration institutes right now, you can try applying for job over there. And you can also do LLM, having a specialization in this field, and do several other arbitration training programs. That these are the ways through which you can become an arbitrator, and there is no age restriction. It all depends on your skills. Even though retired judges are hired, but still, even experienced people, like having knowledge about, all you need is the skill. So if you are a young law graduate who has the skill, who is aware of all the scenario, because you are going to resolve the matters of the company, right? So you cannot be having limited knowledge. You should be having knowledge about how to draft a contract, how to review a contract, how things are working in corporate sector, what is intellectual property rights, what is mergers and acquisitions. You should be aware of all the things. Arbitrational setups are mainly done in your corporate sector only. So having knowledge about the corporate world will help you a lot in creating your career in arbitration and mediation in India. So you can add these skills. We provide several courses on contract drafting, IPR, mergers and acquisitions. Check out our website for the same. But it is easy to become an arbitrator, provided that you are developing your skill sets in that manner. Next is your how to become a mediator. Same as with the mediator. You can have a, like any lawyer who is currently practicing can become a mediator, provided you have knowledge about the field. You can also add a training. So there are several this thing institutes that provide training to you. These are long trainings, okay? These are 40-hour training, 50-hour training provided by the proper mediation centers. So this is a long way run. For now, if you want to directly get an internship or directly get into corporate, having knowledge about ADR will help you a lot, and that certification you can get from Ledroit, okay? So there are like different empanelments nowadays, like we have Samadhan as mediation centers. In high court, there are several mediation centers in court as well. You can start participating over there. Then there are several private mediation institutes as well, which are upcoming. You can directly Google them. Most recognized institutes are your CAM, Indian Institute of Corporate Affairs, international institutions like CDR. So all these things. So there's a huge scope in international arbitration and mediation as well. By practicing in India, once you develop your skills, you can also take up the international matters. Okay, so have knowledge about international laws in that scenario, have knowledge about your proper how things work in corporate. As I said, arbitrational settings are mainly done in your to resolve corporate disputes, so you should be aware of how things are working in industry. So for this you can check out our another video, understanding contracts used in various industries, that is there on YouTube. You can check out that, where we have covered like what is the importance of each contract, how each industry works. It will give you like a lot of insights about each industry, like your IT sector, real estate sector, media and entertainment. You'll get an idea about it. Okay. All right. So now let's understand what are the career opportunities for law students and legal professionals if they have knowledge in ADR. First is you can become an arbitrational counsel. You can become a sole arbitrator or mediator, or you can also become an in-house counsel for dispute resolution. So who are in-house counsel? In-house counsels are the lawyers hired by the company, having knowledge about corporate settings and how to resolve a dispute as well. Okay, you can also become a case manager at arbitration centers. So in arbitration, it's not just a third party, even they need lawyers. So the way the proceedings take in court, like the judge sits in between and two lawyers represent the party, same setting can be in your arbitration as well, where the arbitrator is sitting in between and the two lawyers are representing in front of your arbitrator. Okay, then you can also participate in legal research, you can also become a professor in arbitration, and so there are a lot of career opportunities in your ADR. So, yeah, I already covered the global trends. Nowadays, ODR is increasing because we know that businesses are working online. So, parties, it's not essentially required that you need to be in India in order to run a business in India, right? You can stay in UK or US and run a business in India. So, same goes for the dispute resolution. Parties are now sitting at different places and resolving the dispute. Even when it comes to your this thing, like in your ODR nowadays, several technologies are being created. Like we have now AI, in the same manner several technology is created, like the platforms are being created to resolve the matter virtually. There are several AI based tools that are coming up, which the companies are now using to resolve the matter. So there can be chances like in near future there will be an AI sitting as a mediator giving you suggestions on how you can resolve the matter, right? So I hope you found this topic very interesting and this was helpful to you. Do let me know in the comments if you found the session insightful. If you have any feedback for me, then also let me know so that in the next session I'll, try to perform better. If you have any suggestions for any topic, then also let us know in the comment box. Do make sure that you are liking, sharing, and subscribing to our channel. Follow Ledroit India for more, and do check out our website www.ledroitindia.in for checking out practical skills. In all Ledroit courses, you are going to learn practical things, and in our ADR course, you are going to learn about how to draft arbitrational agreements, how to draft ADR clauses in an agreement. So stay tuned for more. Thank you very much.